Now there's going to be a poll put up on your screen, and we're going to ask that you complete the poll so we have a little bit of sense of who's in the room. And I'm going to go ahead and read the bios of our amazing list of presenters. First, we have Alicia Montgomery, who is a licensed clinical social worker, learning and education director and practicum at East Bay Agency for Children in Oakland. She earned her MSW from the University of Washington and a Bachelor's of Social Work from Southwest Texas State University. She's trained and provided therapy and social work in Seattle, Baltimore, Amogrondo, New Mexico, Austin, Texas. And she's worked as a medical social worker in the emergency room, as well as a child HIV social worker. She supervised transitional and homeless programming in Seattle and participated in New Mexico's rollout of the collaborative task force to reduce child trauma during investigations. She's developed Project Permanence, the current wraparound foster youth program for Alameda County. But most recently, she's been developing and presenting trainings on internalized racism, colorism, becoming an anti-racist, spirituality, grief, and loss. And we're so glad that you're here with us today, Alicia. We're just so appreciate that. Next, we're going to hear from Kristen Boney, who is a supervising attorney at Legal Assistance for Seniors. And she's worked at LAS for over 14 years and represents seniors who are petitioning for legal guardianship of minors in their care. She is also appointed by the court to represent proposed conservatees or serve as guardian ad litem in conservatorship cases. She conducts community education presentations about guardianship, advanced healthcare directives, and other areas of law for older adults and service providers. She represents LAS at the Alameda County Bar Association's Community Projects Committee, the Alameda County Kinship Collaborative, and the nationwide Legal Information Network for Kin. She is also on the board of East Bay Trusts and State Lawyers. Kristen received her Juris Doctorate from UC Hastings College of the Law and her Bachelor of Arts in American Studies from Wellesley College. Next, we're going to hear from Marcy Neff, who graduated from UC Berkeley Law in 2000 and has spent the majority of her legal career representing children in the child welfare system in Alameda County. Ms. Neff worked at the Alameda County Public Defender and later East Bay Children's Law offices as a juvenile dependence attorney before taking several years to focus on raising her own 2 children. Most recently, she's returned to East Bay Community Law offices, where she is now the supervising attorney of Probate Guardianship Division, which is appointed by the Probate Court in Alameda County to represent children in probate guardianship proceedings. Next, we'll hear from Tori Porrell, who is a staff attorney at East Bay Legal Aid on the youth justice system. She represents young people in all sorts of civil legal issues, including legal guardianship, public benefits, school discipline, special education, family law, consumer protection, and name and gender changes. Prior to Bay Area Legal Aid, Tori worked for 3 years at the East Bay Children's Law offices, representing children in foster care in Alameda County, with a special focus on children ages 0 to 5 with complex developmental, educational, mental health, or medical needs. Tori received her Juris Doctorate from Berkeley Law School and her Bachelor's of Arts in International Affairs from Northeastern University. So as you can see, we have quite a wonderful panel for you today to be talking to us. And we do have the poll. Looks like it's been completed. You can see who we all are. And some people may be sharing in the chat who they are, those that didn't quite have a box that represented them. So we have family advocates and healthcare providers, looks like mental health providers, a lot of social workers. Yay, I'm also a social worker. So gosh, I'm just so happy that you're all here with this broad spectrum of participants. So, and then someone from the intensive care unit at Alta Bates, a child life specialist, love child life specialists. That's such an incredible gift to be doing that for families. Someone from Roots, Temescal librarian. So yay, someone from Bananas, the professional development manager. So welcome to you all. I don't need to be talking anymore. I will be monitoring the chat and will be sure to put your questions in the chat and I will gather them. And at the end, of the, most of the speakers will have the questions then. But during Alicia's training, she is open to having you interrupt if you want to raise your hand, put something in the chat, or even unmute yourself, and we'll be happy to hear your questions. So we're going to start with Alicia Montgomery today. Thank you so much for being here, and take it away.
Okay, I had to unmute myself too. I have got, let me go back. There we go. That's my first slide. So thank you all for being here. I think I'm going to go ahead just because I've been having some So we're going to be talking about supporting young children, right? And the grief and loss. So with regard to overview, before we discuss the stages of grief at developmental stages, it's first important for us to understand what's considered normal developmental stages for children. So I think this is a really important thing because we like to jump straight to how do we take care of it, but you know, it helps to understand specifically depending on what lens you're looking through, you know, what is your purview per your job. So since the inception of developmental theories, Erikson and Piaget have taken the forefront. So there's been continued research since so there's growth in that, but these were some of the fundamental stages that we were talking about. So grief impacts our development, and it's important to recognize, you know, that it's completely normal, a grief response, and how children adapt to the particular stages. The first one is early infancy, which is where the first year and a half of trust and mistrust. Who is this person? Okay, I can trust this person that's really taking care of me. The rest of the world I'm not sure about, right? Toddlers are really talking about like kind of discovering themselves. They're able to move around a little bit. So it's autonomy, learning about themselves versus, you know, some doubt or shame, right? They're starting to have a little bit more of a spectrum of emotions and how they can show how they're presenting in the world. Then we have early childhood, which is 3 to 6. And this is when they're really, you know, the no stage and everything. They're showing a lot of initiative, and they also have guilt when they can't do things, right? Or when things come up where they're not, oh, I can do this. Oh, I didn't do it right. So all of those types of things we go through, and after this, they're in school. There's history versus inferiority, because this is how adults, you know, quantify how they are in the world. Am I inferior or not? Adolescence, we love these ages, right? Identity confusion. Who am I? Where do I fit in this world? Let me push my parents away. I need to have my own autonomy. So then young adulthood is 19 to 40, which is intimacy versus isolation, right? Do we couple? Do we not couple? How do we actually create community, family in these ages? And then middle adulthood, which is the 40 to 65. This is a lot of the creating and stagnation. Can you actually create in the world? You know, so many men end up with like identity formation around their profession, real challenge, which goes into the older adulthood, still useful to the society. Where do I get my health, my wealth, my disconnected? This is Erikson, 1982. So the Piaget suggests that children's journey through sensory, motor, pre-operational, these are different stages that they go through. And that their ability quantitatively changes at each stage. He also believed that cognitive development was a continuous process in all children, even in different contextual contexts. But none of that was actually studied by him, but he did believe that. Okay. So one of the first stages they have in their cognitive development is sensory motor, which is birth to 2. And that's really around seeking to understand themselves or other objects, people around them, right? They have deferred imagination. So object permanence is really that peekaboo. Are they there? Are they not there? Does something still exist when I cannot see it? So based on Piaget, during the sensory motor, the essential developments that occur. First 18 months and express limited vocabulary, but 2 years they can express short or meaningful sentences. Secondly, children at the end of the sensory motor development develop their capacity to imitate others, right? So this is what he was talking about when he says deferred imitation, the ability to reproduce or model activity that has been witnessed, okay? So studies demonstrate that many cognitive capacities among infants emerge earlier than Piaget. So even though this is kind of a foundational, I want you to understand that, yeah, now we've got 2-year-olds with smartphones. We didn't have smartphones 30 years ago. So we continue to develop, and how do we actually adapt to the society that we're in? So again, from birth to 2, infants at this stage seek to understand objects by using their senses, right? So how is this characterized in this deferred imitation, right? How do they actually replicate? Again, what can they sense? The pre-operational stage is 2 to 7 years old. This is around animism. And I like to point out, when we use the word animism here in the mental health field, it's completely different than animism in the spiritual world, which means that everything really is alive. Okay. And that's a spiritual belief practice, different from the way we're talking about it in Piaget. And so children do give life and refers to the child's inability to differentiate between their perspective and others. So still understanding they're an individual and not part of their caregivers, and how do they actually create themselves separate. They're just starting to understand, oh, I'm not actually attached. Conservation refers to the ability to recognize that something remains the same amount, even if it's the same shape. So in these ages, this is when the children are in the sandbox, pouring things back and forth, understanding that, oh, this is actually the same amount, but this is what they're doing in their repetitive play, is understanding conservation, and that shows up in their life. So then you have pre-operational again. So the first limitation of pre-operational stage is animism. Animism is the ability to distinguish between animate and inanimate objects. Children in this stage believe that everything around them is alive. For example, Santa Claus is not a real person, but because children usually see him on TV and pictures, they believe he's alive, right? So something that, most people.
Okay. So in regards to egocentrism, although there's some that have studied Piaget's study, egocentrism, most experience has shown that a child takes other people's perspectives earlier than Piaget suggests. This is important because we're actually looking at the developmental stages and how we as human beings continue to evolve, right, as we're moving along this spectrum. So let me just keep going on because I don't want to cut into everybody else's time. Okay. So conservation is the ability to recognize that something that remains the same, right? So it's important when we think about some of these concepts that children are then able to understand that, that when we're moving things around, or that their father can be an uncle, can be a brother to somebody, can be someone else's child. Okay, so in contrast, studies have shown that pre-operational children have the ability of conservation. Preschool children are able to do conservation tasks that are appropriate to the level of thinking and understanding, right? So how do we actually look at the child and understand where they are? Because as we well know, many children actually are developing much earlier. So for example, an experimental judge study, manipulate complexities of tasks to judge conservation ability among young children. That children even younger than 3 years old can perform conservation tasks successfully. So this is how much our developmental abilities have shifted since the well, not Piaget's earlier than Erickson, but, you know, in the last 60 years. So it's important for us to understand what it is that children actually do in regards to the development, how they can think, what they're able to perceive and not perceive. So then as we move into these types of losses, it's important for us to understand what is actually impacting this child. So they can have ambiguous loss, so they don't actually understand what happened. So it's closure without understanding, and that has a lot of impact on their the context. So how do they process through? They tend to be on an emotional roller coaster going up and down because they don't know what to attach to. There's nothing to. And often they can withdraw, right? And so we really want to help them to learn to live with the ups and downs so that they can actually move through their feelings and be able to express them in the way that they possibly can at their actual developmental stage, okay? There are many different types of franchise losses. So these are not publicly acknowledged. So when they lose a friend, for this is just a more general list. So obviously it's not specific to 3-year-olds, but let's say their parent gets incarcerated or there's a loss in the home, all of these things that impact children, suicide, homicide, how many of them are immigrants? What is their life shifted in the last 2 years because of COVID? And how many people have become homeless, right? Or houseless. So all of these things are different ways that children are experiencing loss that is not in relation to death or dying. So then there can be the sudden and traumatic loss. And so the child is left with, again, with unanswerable questions. Thank you. So it's really important to also remember, and this is really important for therapists to remember, that a traumatic loss depends more on how the event is experienced and understood by the individual than what happened. You have two people in the same car wreck. One walks away traumatized, the other one does not. And this is the same with twins. Everyone is an individual. It's really, really important that we slow down as professionals to really be curious and ask questions that give us the answers to understand what is going on behind for this child. So there can just be the separation of distress, right? Got a separation disorders, right? Traumatic emotional distress, people will become numb. There's a level of disbelief. Then there's becomes distrust, anger, emptiness, right? So all of these things are possible with these children. And so when we understand this, right, the traumatic loss, that it also impacts other things, intrusive memories, nightmares, and how do people become numb. Adults are really good at this, and so children learn to mimic it or to accept that that's a normal process. Remember, children learn more by what they see than what they hear. So, moving into grief and loss, infants 2 and younger. So how do they understand it? They have no concept of death, but they absolutely do react to the emotions of the caregivers around them or the loss of one, right? So what is going on in this child's daily life and what has shifted? That's a huge deal, right? Somebody's there and then they're not. It's no longer peekaboo, right? So they may present with irritability, anxiety. They may do a lot of crying that they may seem inconsolable, right? Beyond colic. They may completely become clingy, right? Or have separation problems, difficulty sleeping, restless and rocking behaviors. They're also going to be doing some self-soothing of sucking and biting, and they might have all of the somatics, right? What's going on with their body. Children become imbalanced. They don't know, and they do not have the verbal capacity as adults do to articulate it. Therefore, it's going to always be in their behavior. Remember, children's language is through their bodies at this age, not through their words. So children ages 3 to 6, how do they understand it? They understand there's a profoundness, but they see death as temporary. They don't understand that that person is not coming back, right? So it's important that we're actually using articulate language grandpa died, right? So that they don't, euphemisms such as past or lost, even though these are culturally utilized words in a memoriam, it's really important for us to understand that when we're speaking with young ones as professionals, it's really important for them to understand that somebody died and that they're not just coming back, right? And I will also say that that's one of those things that comes up a lot in supervision is, what if the family, oh, we don't use the D word. Well, okay, they don't use the D word outside of here, but if the child needs to use that word, how do we actually align with our clients to be able to help them? And how do we actually help caregivers understand that utilizing real words that mean exactly what they mean is really helpful for the child, because their grief may not be the way that the parents is. So it affects their sense of security. They may attach to another, which is not unusual, right? And their acting out behaviors are going to happen, right? There can be some regression. Again, the nightmares, the aggressiveness, the non-compliance, right? They're really defiant. They're angry, and they don't know what to do with all of these feelings that they don't even have words for. It's just rippling through their body. So children can grieve, and it can include things like general anxiety, irregular sleep, increased needing to be held, right? And again, the regression. So how are they actually doing this? A young child can express strong feelings in their sleeps and dreams. So they may have very vivid dreams. They might talk about it or not, or they just wake up. Remembering that children, their expression is through their play. So you'll see a lot of repetitive play. How does that show up for them? What's going on? And they may express their sadness only for a short time. And this is where a lot of times adults say, oh, they're not really grieving. They don't really understand. They grieve, they understand. They don't have the ability that adults do to fixate on it, right? As children, they can cry for a little bit, but their grief may be just through the actual playing to be able to move it through their body. And so then oftentimes they can be more spontaneously more recovered than adults because they're able to move it through. They have good coping mechanisms. They haven't put the blinders or the suppression on that we as adults do, that we override our feelings by our frontal cortex and be able to say, oh, I don't want to feel that. Children don't do that. They haven't learned to do that unless they do learn to do it, and then they do, right? But children need routine. Even if they're angry, they need to know where the walls are. They need the reassurance that there's structure in their life, there's affection in their life, and that they know what's expected, right? It's really important for them. Even when they're resisting, it's helpful. So how can you support it? Normalize their reactions and allow them to express their feelings in ways that feel natural for them. Really important. You have to keep your eye on the prize. Who are we speaking about? If we're talking about the parents, that's one step. But if we're actually talking about these little children, what is natural for them? How do they? Do we slow down as adults to actually take the time to pay attention to their play, engage with them, listen to them to understand what's going on for them? Validating their feelings. Patience, 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 right? You may have to explain things 20 times. Can you do that? Allow them to tell their story without judgment. They may have their own story that they're working through, just like their play, and it may be repetitive, and it may not be exactly the same as what you understand. Allow them to ask questions and answer the best you can. I always like to remind people, just answer the question. You don't need to belabor it. Answer the question that they asked, because we like to try and explain things. Just answer the question that they asked. If they want more information, they will continue to ask, because they know now that they can ask a question and get an answer from you. Okay? Use clear language. Children need to understand their relationship with language and that this person is not coming back. Understanding that there's behavioral changes as part of this grief process, the regression, the anger, all of those things. You know, if this is an older child, they may not be able to do well in school, right? So how do you actually recognize what's going on with these children at the time? It's important for us to be present, authentic, and patient. Listen more than we talk, and avoid trying to cheer them up. Our job is not to cheer them up. Our job is to be present with them, let them feel their feelings, talk with them about them, help them move them through so that they can be in their own grieving process and heal. And express all the emotions. Don't make their behaviors, don't make them bad. Just when we don't like children's behaviors, that's fine, but we need to understand it's like, oh, okay, well, I understand you're really angry. Let's find a different way to be that way, right? To express that and show empathy. And it's okay to let them know that you have feelings too, right? As long as you're not making it about you, it's important for them children to understand that you actually do have a set of feelings and that what they said really impacted you. So other ways to help is stick to routines, give concrete choices, right? It's hard when they have to figure out what you mean. So there's a solid A, a solid B, a solid C. They pick D, no, there's only an A, B, and a C. Answer questions honestly, provide different types of activities for them to express themselves, not just through their play, but through arts and crafts, through music, through, rolling down hills, all of it, writing activities. What actually engages the child? What is it that'll help them move their grief through themselves? So help children to identify people and activities that help them feel safe and supported. What are the things that help them feel good about themselves in their own body? Because they can have dissociation otherwise, right? And how can they feel safe in their environment? Who can they go to when they don't feel safe, right? It's as simple as, I woke up, I didn't feel safe, I crawled in my mom's bed. That's important for them to identify ways so that when it does come up, they're able to move through it. And adjust our expectations when it's appropriate. Like thinking about if they have concrete tasks or completions that they need, can they actually do it when they're in a particular grieving state or not? How do we actually help them to move through those things? Remember, they're trying to be industrious at this point. So when we think about helpful language, I know exactly what you're going through. How about, can you tell me more about what this has been like for you? Open-ended questions. Instead of, you must be angry. Most people have strong feelings. What's this been like for you? Instead of it's hard, right? And trying to remember good things. I hear this is a really hard time right now. Like allowing them to choose how they feel and not put qualifiers on it for them to feel like, oh, I can't actually show my real emotions to this person, right? I hear this really hard time. At least you had many fun memories together. With what do you think about when you think of this person, right? This is really important. How do we actually change our language so that we're actually creating openness for the child to express it without judgment or fear? So when they have triggers, identifying a safe space where they can go, where they, in their home, if they're already in school, what are the places that feel safe internally and externally? Who can they reach out to? Permission and encouragement for the child to spend time talking with whomever, other peers and adults that are going to help them, and offer private time to talk over feelings and other concerns, because most people don't like their business in the street anyway, right? So why would this be true for children? How do we actually create an ability for them to feel safe to actually express their emotions? This is an intervention that we do, and it's called a grief tree exercise. This will be in the PowerPoint, but you basically are drawing the tree. If we had time, we would go through this. And the idea is, who is this special person? What did you learn And what are your resources? And what did you appreciate about this particular person and this particular relationship? This can be done at any age. The idea is how do we help children connect into their feelings in a way that's going to help them heal? Because they have to be the ones that decide what's going to heal them. And if that means running around the playground every day for 20 minutes and screaming, and that's an okay thing to do, then why not, right? We don't want them to keep their trauma inside. We want them to be able to move it through them so that we can release the trauma from their body. Are there any questions?
There aren't any in the chat right now, but please feel free to unmute yourself if you have any questions.
Can I ask a question?
Hi, Emma, go ahead.
Hey, can you guys hear me okay?
We can hear you, Emma.
Okay, perfect. I just was going to ask, Alicia, thank you so much for this presentation. It was super, super helpful and beautiful to think about different tools to use. I feel like sometimes when I'm like acknowledging the death of a loved one with a child, I want to use words like, okay, this might be like my hippiness coming out, but like, you know, is in another dimension, or maybe like their body has passed on, but their spirit is still living. And I want to like speak about it in a way that leaves open the door that like they can still very much be alive here for you. But the body might not be here, but I guess I'm trying to like fit that in with your suggestions. And so how do you feel about that? Do you feel like there's a way to do that while not confusing them too much?
To answer your question, yes, I feel like that's perfectly reasonable, and I would actually advocate for it as part of your psychosocial assessment. What I would do is I would ask an open-ended question about, you know, do you still feel them around you? How do you still connect with them? Do you still connect with them just because their body's not here, right? Because what it is it kind of is on the edge of spirituality for many people and what they believe. And so then the question is you don't want to necessarily step into a hornet's nest of conflicting the beliefs of what the caregivers might believe, but you want to explore what the child believes, because often what I've seen is children do not always believe what their parents believe, but they believe what their grandparents believe, right? And so when you're dealing with that kind of transfers of information and belief, then that child really wants to make sure that it's like, okay, can I tell you, are you safe? And yes, I still talk to my grandmother every day, but my parents don't believe in that. Yeah.
Okay. Thank you so much. That's super helpful. Thank you so much.
Right.
Yes, there's another question about how to handle physical and emotional anger towards a caregiver. And I'm not quite sure if it means the child has physical and emotional anger towards a caregiver, or if it's the child. I'm not exactly clear, but
I'll unmute.
Yeah.
I have muted myself. This is Pat.
Thanks, Pat.
You're welcome. This is a 10-year-old who lost both parents, one 3 years ago, the other one a month ago. He's very angry physically and emotionally, in therapy, seeing child life, but nothing seems to be helping.
Yeah. Okay. So when you say towards the caregiver, they're angry for being left. There's abandonment issues there, right?
Oh, I know the answers to why. I'm challenged as to how to move in a direction that's therapeutic.
Well, I would actually see what I could do to work with the anger. So anger is neither good or bad. It's just an emotion that has to ripple through. So then if we, you know, in this case, maybe using some narrative, like how do you externalize the actual behaviors of anger and actually be with the anger? Like, what do you need to channel it? What are ways that will not get you in trouble, maladaptive, and be able to do that? Can you write your angry letters? But I would actually focus on or give them expression of how do they want to utilize and move the anger through them, whether it's through drawing, through painting, through journaling, through running, through mute, so I've seen kids express it in so many different ways, but I would actually give them license to move through the anger in a way that's not going to hurt them or hurt someone else.
Okay, thank you.
Okay.
Any other questions people have? Well, this has been really great, Alicia. Thank you so much. We appreciate you and the work you do so much. So if you have further questions that come up, go ahead and put them in the chat, and Alicia is going to stay on with us. So maybe at the end we can revisit those.
Yeah, and I just also want to say, Pat, I don't know if that really landed or if it was helpful, but I'm always also you're welcome to reach out to me and we can have a different conversation or a longer conversation off.
Thank you
screen.
so much. I appreciate that. Thank you.
You're welcome.
Great. Thank
I'm
you,
going to mute.
Alicia. Next, we're going to be hearing from Kristen. And Leah, thank you so much for putting her PowerPoint up there. Kristen Boney, thank you. Go ahead, and then we'll hear from Marcy and then from Tori.
Hi, thanks so much, Beth. So as Beth said previously, I'm Kristen Boney. I'm a supervising attorney at Legal Assistance for Seniors, and we're a nonprofit organization in Oakland. And I want to thank Alicia for such a great presentation. I'm an attorney and I work with caregivers who are taking care of minor children who are often experiencing grief and loss. And I feel like I learned so much from the social workers and the therapists that they work with and from presentations like this. So if I could have the next slide, please. The Legal Assistance for Seniors, a little bit about us. Our mission is to ensure the independence and dignity of seniors by protecting their legal rights through education, counseling, and advocacy. And all of our services are free of charge. Next slide. These are some of the different areas that we help our clients with. We help with public benefits, senior immigrant issues, elder abuse prevention, kin caregiver issues, which is the area that I work in. I work on legal guardianships. We also assist with planning for the future, healthcare coverage, including Medicare and Medi-Cal, and we have a housing law department as well. Next slide, please. Our HICAP program is health insurance counseling and advocacy, and we provide assistance with Medicare and related health insurance by offering objective information to consumers about their benefits and options. And because we're a nonprofit, we're not trying to sell people anything. We're just providing information when people are signing up for Medicare for the first time, when they might want to switch their plans, or when they have issues come up throughout the year with billing and other things. People are always welcome to call our HICAP program. Next slide, please. So today, in talking about older adults that are caring for children, there are several different legal custody options that I want to explain. The first is informal arrangements between parents and caregivers. The next is probate guardianship. And then we'll talk a little bit about juvenile dependency and adoption. Next slide, please. So informal arrangements. This is usually an agreement between the parent or parents of the child and the caregiver who's going to be taking care of the child. This can involve a power of attorney or other decision-making authority that's given to the caregiver, or a form called the Caregiver's Authorization Affidavit. Next slide, please. So when there's an agreement between parents and caregivers, this is when there's no court order that's giving legal custody to a caregiver that's not the parent. This can be adequate when the caregiving is just expected to be a short period of time, like a hospital stay or sometimes a military deployment, when there's no need for formal custody. And sometimes this is used when a caregiver fears upsetting the child's parents. Sometimes, everything seems fine with the child in the home with the caregiver, the parents are outside of the home, but the caregiver knows the parents would be upset if the caregiver tried to go to court and get authority to make decisions for the child. Next slide, please. The advantages to this are that it's pretty easy. It's informal. It's less likely to cause negative feelings or actions by the parents. And the arrangement is easily changed. The children can go back to the parents without a court having to make a decision that that's in the child's best interest. The child can go back and forth between the parents and the caregiver. And the caregiver is not legally responsible for the child. And I guess to back up a little bit, a lot of the cases that we see when older adults call us, they've been caring for a minor child or children for different reasons. Sometimes the parents have died, sometimes the parents have substance abuse issues, or they're incarcerated. So we do see a lot of the grief and loss issues come up that Alicia was talking about in her training. So there are a lot of different scenarios that we encounter when we are talking to somebody for the first time and counseling them about their options. Next slide, please. The disadvantages of an informal agreement are that the parents can remove the child at any time. A lot of our clients, in their cases, they have parents who do have substance abuse or mental health issues, and they might be wanting to take the child to a situation that's not safe and not understanding that it's not safe for the kids. So the disadvantage is that the parents can do that at any time if there's no court order. The caregiver might also have difficulty enrolling a child in school, authorizing medical or dental care for the child, or signing up for public benefits on the child's behalf, especially if the parent is already receiving public benefits. The agency might want to see a court order before they'll switch that. Next slide, please. With a power of attorney or a decision-making authorization, this is a written private agreement that would be signed by the parent or parents and ideally notarized. And it would give the caregiver permission to make decisions for the child. Next slide, please. The advantages are that the parent can make this decision. They can authorize another adult to make decisions regarding medical and dental care for a child. This is by state law that those categories are things that you can authorize another adult to do. This is likely to be recognized by schools, medical professionals, and social services, and it allows the parents to give the caregiver authority without having court involvement. Next slide, please. The disadvantages, much like the informal agreement, is that the parents can revoke this at any time, and the parents can remove the child from the caregiver's home at any time. So this might disrupt, a long-standing stable arrangement that the child has really become used to. It doesn't change custody legally, and it's not sufficient for someone who's not related to the child to get public benefits for the child. Next slide, please. There's also a document called a Caregiver's Authorization Affidavit. And this is a form that's created by the California legislature, and schools and medical providers have to accept the form. It's valid for 1 year, and caregivers can renew it after it expires after a year. Next slide, please. There are two types of this authorization. If the caregiver is not related to the child, they can use this form to enroll the child in school and consent to school-related medical treatment. So that might include vaccines or other things that are required to enroll a child in school or keep them in school. If the caregiver is related to the child within a certain degree, they can use it to do the above things and also consent to general medical and dental care. So beyond what the non-relative can consent to. Next slide, please. The advantages are that this is easy to obtain. Anyone can print this out online. Our office regularly sends this form to clients. And you don't need to have the parent's signature, just the caregiver has to sign and say that they've either informed the parent that they're going to be making these decisions or that they can't locate the parent. It allows the caregiver to have authority without court involvement. And as we'll discuss later, the court process is really long and pretty invasive. So that's a real benefit. If there's nothing requiring a court order, it's a real benefit to just be able to sign a form and then give it to schools and medical providers, and they should accept that, as we discussed before. Next slide, please. The disadvantages, again, are that a parent may override the caregiver's decisions, and it doesn't change formal legal custody. The parent can still take the child from the home, and if the caregiver wants to enroll the child in their private health insurance, the child might not qualify. They might not be able to do that. Next slide, please. So then we come to probate guardianship, which is the majority of the practice that we handle at Legal Assistance for Seniors for older adults who are taking care of kids. Probate guardianship is a formal legal arrangement that exists until the child turns 18 or until the guardianship is terminated by the court. The court finds that it's in the child's best interest to terminate the guardianship and return the child to the parents, or to have another guardian appointed. Sometimes we have a successor guardian if the first guardian is not handling the guardianship appropriately or no longer able to serve. The caregiver has to file a petition with the Superior Court Probate Division. And that's what our office assists with. We have programs where we help people who are self-represented, and we also represent some clients as well. And the probate guardianship suspends parental rights to make decisions for their children. So the court typically definitely wants the child to visit with their parents if there's a safe way to do that. But the guardian takes over the authority to make decisions about where the child goes to school, medical decisions, and other things like that. Next slide, please. The advantages are that this provides a greater sense of stability and security for the caregiver and the child in their care. Legal guardians can make all child rearing, medical, and educational decisions, and no one, including the parents, can take the child without the guardian's consent. This may qualify the child for the caregiver's private insurance coverage, and only the court can modify or terminate the guardianship. Next slide, please. The disadvantages are, as I said before, the process can be intrusive. There's a court investigator who works for the court that does a thorough background check on proposed guardians and everyone living in the home with the child as well as parents. Proposed guardians have to disclose all of their criminal history and all of their history with CPS. And that can be really sensitive. You know, we have a lot of clients who had some issues come up maybe in the 70s and they were expunged and they've moved on with their lives. And it can be really painful to have to relive those things and disclose it to the court. Even though the court isn't going to be concerned about those old issues, it's still really hurtful for a lot of clients to have to bring those up and talk to people that they don't know about their past. Parents can also fight the guardianship petition. This is called contesting. And it can be a lengthy, stressful process that can ultimately result in a trial if the parties aren't able to come to resolution on their own. The public benefits that you are eligible for might be inferior to those obtained through juvenile court. And if your guardianship petition is not granted, you may have difficulty seeing the child if the parent is angry that you filed the petition. If appointed as guardian, the guardian may be responsible for the child's behavior and any damage that the child may cause to other people's property. Next slide, please. And I want to talk a little bit about the dependency process. I think Marcy and Tori, our next speakers, are more familiar with that process, and it's not a big part of our presentation today. But this is when, I think colloquially we understand the agency as CPS. Now it's referred to as the Department of Children and Family Services. But this process starts when a child is removed from the home by the department or by the police, and then the agency files a petition in court if it believes the child is being abused or neglected. And so it's something that's really beyond most caregivers' control. It's something that the agency determines whether the petition should be filed and then where the child should live. And it's a little different from our proceedings because the court offers a lot of services to parents, and both parents and children are entitled to attorneys. And if the parents can't afford an attorney, one will be appointed for them. And caregivers don't automatically have standing to participate in the proceedings. So unlike probate guardianship, where the caregiver is really driving the petition, they've filed the petition, they can decide whether to proceed or whether to drop their petition. In this one, the county is really controlling the petition since they filed it. Next slide, please. And as we discussed, the child must be in immediate danger of abuse or neglect in order to be removed from the parent in this process. And there is additional information, and you'll all receive these slides. I know that the link has been posted in the chat to the slides, and you'll also receive them by email. So next slide, please. And then adoption is different from guardianship in that permanent parental rights are given to adoptive parents. So a lot of people like guardianships because the family relationships are preserved. If a grandmother is taking care of a grandchild and they become a guardian, in the eyes of the law, they're still the grandmother. They just have legal guardianship and they're able to make decisions for this child. In an adoption, if the grandmother went through that process, she would actually become the parent of that child, and the former parents or guardians' rights would be terminated. Next slide, please. And so the probate guardianship process is quite lengthy. The proposed guardian has to prepare and file a lot of court documents and provide parents, grandparents, and siblings with notice of the hearing. The court investigator will do an interview with the proposed guardian and the minor or minor children, and do a background check on all adults that are living in the home, as well as the parents. And then the caregiver and the minor or minors will attend a hearing at the probate court. The children are typically required to come to the first hearing, and then they don't have to come to hearings after that. If the procedural requirements of the court are met and there are no issues that the court finds with the parents or the proposed guardian, the guardianship can be granted at the first hearing. That's really ideal. But if there are any issues with the paperwork, or the court has concerns about the proposed guardian by looking at their criminal or their CPS history, or if a parent objects, the case might be continued for further hearings. And sometimes, our court has done different things over the years. Sometimes it stays in the same department with the same judge. Sometimes it gets transferred to family court, so you're kind of starting again with a new judge. Next slide, please. And now I'm going to turn it over to Marcy to talk about the role of minors counsel in probate guardianship proceedings.
I'm Marcy Neff. I am currently the supervising attorney in the probate guardianship division of East Bay Children's Law Offices. We're a pretty small division. It's myself, another attorney, and a social worker who happens to be present at this training today. And we are, as Kristen pointed out, we are not appointed on every case, every probate guardianship case in Alameda County. We are only appointed in certain types of situations, primarily when a parent objects to the establishment of the guardianship in the first place, we will often be appointed. And also sometimes we can be appointed when the petitioner, who's usually a family member, an extended family member, has a lengthy CPS history or something else in their background that concerns the judicial officer hearing the case, and they want to have more information. And our role in the proceedings, in probate guardianship proceedings, is really to provide a voice to the child. So what we do is we go out, we interview the child, we talk to the child and the family members, we talk to all the parties that are involved. Sometimes the parties will be represented by attorneys. A lot of times they are not. So we will have conversations with them and with the children and try to figure out what is going on with the family. And we will represent to the court what is the child's stated interests in terms of what they want to see happen with respect to the guardianship, with respect to their family, with respect to contact with their parents, if that's an issue. And with respect to what else is going on in their life, so the court can have a really good overview of their circumstances, where they're at in terms of their education, what special needs they may have that the court wants to be able to ensure are being met by whatever caregiving arrangement they're in. And then we report this information back to the court, either in a written report or orally during a hearing in the matter. Our recommendation to the court as to whether or not there should be a guardianship or as to what type of arrangement there should be in terms of visitation, not visitation, et cetera, carries significant weight with the court because we are seen as neutral. Also, the stated interest of an older child carries significant weight with the court. And when I say older child, I mean, most likely we're talking about teenagers or a child that's over the age of 10 who, can really articulate very clearly what it is they want. And what it is they want is reasonable and well thought out, et cetera. But younger children can also have strong stated interests. And there are different ways of going about assessing what those are. And we work with the social workers and other service providers involved in the case, such as the child's therapist, that they have one, or teacher, to try to determine if a child can't necessarily articulate directly to us what it is they want in terms of guardianship or not guardianship, to try to figure out what is in their best interests, and also what is the nature of their relationships to everybody who's involved in the case. Next slide, please. So things that the court takes into consideration in terms of guardianships, in terms of whether or not to grant a guardianship, whether or not to grant visitation, et cetera, is primarily stability, stability, stability. The courts are very interested in a child's maintaining stability, and it's actually written in the law that that is what the court is primarily concerned about. It's also true that the court will consider what the child wants, as I stated before, and who is most likely to maintain relationships with all involved family members. So we have situations when we're appointed and there's a contested guardianship, when a parent objects, there often is quite a bit of animosity that arises amongst the family members, the parents versus the grandparents or aunts or uncles, the different sides of the family, the paternal family, the maternal family. But the court has said and emphasizes that the more people that love a child and that are in a child's life, the better. And so the court really wants to see which party, which side of the case, if you will, is more likely to cooperate in maintaining the relationships so that the child has access to all the people in their lives that love them, and that those relationships are going to be protected. The court will also consider if a child has special needs, such as special education needs, special emotional needs, special mental health needs, who is in the best position to provide for those needs going forward. The courts also will often, when a parent contests a guardianship or seeks to terminate a guardianship, they will also often refer the case to mediation. And we have a mediator that works directly with the families that are involved in probate guardianship proceedings, because the court really does prefer that the family works things out for themselves so that they have a conversation in a controlled, supportive environment where they can air their grievances to a certain extent with each other, but also try to come to an understanding and a workable way to move forward. In uncontested guardianships, where there hasn't been a petition to, or an objection to a petition, we will be appointed sometimes, as I said before, if there's a lengthy CPS history or other concerns that the court has about the petitioner that they want more information on, or they just want to hear directly from the child what it is that they want. We will be appointed in those situations too. And our role then is to work with our social worker who's assigned to our cases to support the family, and also to refer to outside services if those aren't already in place. One of the most important things I think to consider in terms of, as a caregiver, as a provider, someone who is seeking to gain guardianship of a child, particularly in a case where a parent has passed or one parent is incapacitated for one reason or another, and the other parent may object, is that when you seek guardianship of a child, it's not going to be once it's established, if it's established. It's not like the relationship with the other parent, the parent who's left aside, or the surviving parent. That relationship is not going to be over. So I think it's really important for caregivers to recognize that there's going to be a need to continue that relationship. And they're going to have to work with that parent, the surviving parent, if they do become the guardian, on how to repair, move forward in terms of that child's relationship with the surviving parent, so that that child is able to grow up with the surviving parent as a part of their lives in a meaningful way. And I think it's really important for caregivers and parents in these situations to be able to put their own feelings and issues with each other aside and work together to support the child, especially in a situation where a child has lost one parent and they're going to need to move forward because, you know, in being able to have the other parent in their lives. So I think that's it for me.
We did want to let people know that most cases, if you're filing a probate guardianship petition, most cases qualify for a fee waiver. This changed a few years ago. It used to, the court used to look at the proposed guardian's income and assets, but now the fee waiver is based on the child's income, or if they receive certain public benefits like Medi-Cal or non-needy CalWorks, they automatically get a fee waiver. So in nearly all of our cases, even if the child isn't receiving public benefits yet, their income is likely zero. And so nearly all of our cases qualify for a fee waiver. I think actually all of ours have since that law changed. If the fee waiver is not obtained, the court fees are over $1,000 because there's a court investigations fee as well as the filing fee for the paperwork. Next slide. And then, you know, Marcy was talking a little bit about issues that can come up within families between caregivers and parents. And we always recommend that our clients check out the free kinship programs in our county. These programs provide support groups and respite, which is like babysitting for caregivers. And then after school and summer programs for youth. And my clients always report back that the kids in their care love these programs. They will also assist with obtaining public benefits if the caregiver needs help. You know, I think pre-pandemic, they would sometimes even give caregivers a ride to the office and go with them if that was needed. Right now, a lot of them are, you know, some of them are having clients come into the office, some of them are remote, but they are all still working with clients, and they do case management services as well. And they'll do a needs assessment and they'll refer to community organizations. So if the child needs counseling or any other services, they can either provide that or make referrals. So the two that we work with, because we just work in Alameda County, are Family Support Services Kinship Program, which serves Northern Alameda County, and then Lincoln, which is there in Oakland, and then Lincoln is in Hayward, and they serve Southern Alameda County. And their phone numbers are here, or you can Google them, and they have information online as well. Next slide, please. And then this is our contact information that you'll receive either by email, or you can go to the link that's been provided in the chat. Next slide, please. And now I'll turn it over to Tori.
There it is. We got our slides out of order a little bit somehow, but thanks, Kristen and Marcy. That was a great way to tee up what I'm going to talk about next, which is public benefits that are available to caregivers who are caring for children, not their own children. So some of this will be specific to relative caregivers, and some of this will be specific for non-relative caregivers, and it differs by program. Again, there's gonna be a lot of information on my slides that I'm not gonna cover. We're just gonna kind of hit the high points. Feel free to ask questions, and then there will be handouts provided with extra details. And if you have specific cases that you want to refer, we have all of our contact information at the end for how you can refer clients to our legal advice line. But here's just a little bit about me. So I'm a staff attorney at Bay Area Legal Aid. I work on our youth justice team. So I represent older youth right now, generally youth between like 12 and 18, who are actually petitioners in their own guardianship. So youth who are 14 and older can petition for be the petitioners in their own guardianship, and ask the court to appoint someone to be their guardian on their own. And I represent them as the petitioners. Here are just some of the other areas that Bay Area Legal Aid serves and some of the intersections of the communities we serve. Next slide. So here are the programs we're going to cover today. It is a lot, but we are going to do, and I'm not going to cover like all of the eligibility for all of these programs, but we're going to specifically touch on what caregivers need to know if they're caring for children and how it relates to these programs. So next slide. So we're going to start with SSI or Social Security because there are specific Social Security programs that relate to the death of a parent. When a parent passes away, there's specific financial support available to caregivers for their surviving children. Next slide. So there are two Social Security programs. This gets a little bit confusing, but stay with me. So the first one is SSDI, or Social Security Disability Insurance. This might be the one you're familiar with if you have worked and seen Social Security taken out of your check. That is the one you pay into and then can draw from in retirement. And that money is not means tested. There is another Social Security program called SSI, which is a program generally for folks with disabilities. That is a means tested program for people with low incomes and low resources that pays a monthly benefit. In California, it's about $954 for adults, and children are also eligible for SSI, children with disabilities. And the benefit amount is a little bit different. So we're going to talk about these two different programs. So same agency, two different programs and how children can get benefits. Next slide. So SSDI is specifically going to be for children who've lost a parent. So children could be eligible for SSDI if they have a parent who's died after having worked long enough at a job where they paid into Social Security. They will be eligible for what's called a survivor's benefit until they're 18, or continuing until 19 if they're a full-time student in generally high school or continuing in some kind of vocational education, not higher education though. Or if they have a disability. If they have a disability, they continue to be eligible for survivor's benefits until they're 22. The survivor's benefit can be quite substantial. A child can receive about up to 75% of what the parent's retirement benefit would have been. And so this can be a significant source of income for whoever is caring for the child after a parent has passed away. Next slide. So how would a caregiver go about accessing that benefit? It's basically just a matter of contacting Social Security and finding out if the parent had paid into the system, if they had enough work history, and the caregiver would need certain documents. So they need the child's birth certificate or other proof of their birth. They need the parents and the child's Social Security's number and proof of the child's death. And then just basically to contact the Social Security Administration. You can actually do this online now. which is much better than trying to call the Social Security Administration these days. Another important note for this program, it is only for either US citizen parents or those who had legal work authorization. Those are the only parents who would have been eligible to pay into this system and have their children receive it. Next slide. So then SSI is the other program, is a benefit program for children with disabilities. So there's generally 3 requirements to obtain SSI, which are having a disability, which is a medically definable physical or mental impairment expected to last for at least 12 months. Again, because it's a federal program, there's a citizenship requirement. Either the child needs to be a citizen or a qualified immigrant. There's certain types of immigration statuses that would make a child eligible. I won't list them all now, but if that is an issue, please contact our organization and we can consult on that. And if the child were living with a parent, some of the parent's income would be considered in their eligibility. But if the child is not living with the parent, there is not going to be, they're not going to consider the caregiver's income. They're just going to look at that, whether the child has a disability. Next slide, please. And so if a caregiver thinks a child has a disability or a condition that may be considered a disability, they can apply through the Social Security Administration. They should apply as early as possible because benefits are paid retroactive to the date of their application. Important for this type of application are medical and school records. That is what Social Security will want to see to document the disability. So things like 504 plans or IEPs, or generally having just whatever condition it is, whether it's autism, ADHD, orthopedic impairments, anything like that, documented in their medical records is very important. And if a family were to be denied, applicants have 60 days to file an appeal. Denials are extremely common in Social Security, and our organization handles appeals. So if a family were to be in that situation, please contact us. Next slide. All right, CalWORKS is the next program we're going to talk about, which is a cash aid program. Next slide. So CalWORKS is a cash aid program for children who are deprived of the support of at least one of their parents and have an adult caretaker relative. Next slide. So importantly for CalWORKS, there is also a benefit. CalWORKS is generally when parents are applying for CalWORKS to take care of their own children, their income and assets are considered, and they have to be low income and have low assets to receive CalWORKS. However, there's another program within CalWORKS called the non-needy caretaker benefit, which is for relative caretakers who are caring for a relative child who can receive CalWORKS benefits, but their income and resources are not considered. So only the benefit is only for the child, only the child's income and resources are counted. It's important to know also, the caretaker does not actually have to be the child's legal guardian to receive these non-needy caretaker benefits. So as Kristen mentioned, with that caretaker authorization affidavit or under one of those informal arrangements, a relative caretaker could still apply for CalWORKS benefits and get some cash aid to help care for a child. You'll see on the slide, there is a specific definition of close relative of who can get CalWORK, this type of benefit. So if the child is living with a non-relative, they would not be eligible to receive this type of benefit without solidifying or formalizing the legal relationship between them. But otherwise, this can be an option. This benefit is lower than some of the other options that we're going to talk about, just in terms of the amount that caregivers receive. Next slide. And how would caregivers apply? There's a website, mybenefitscalwin.org, or they can call the county social services office wherever they're living. Next slide. CalFresh or food stamps. We'll just go quickly through this one. Next slide. So CalFresh, I think would probably, a lot of us know, is California's version of food stamps or SNAP or EBT. It has a lot of names. It's not a cash program, but it's a nutrition program that offers benefits to buy food. You can only use it to buy food, so you can't use it to buy other things like diapers or medicine or anything else. Next slide. For the purposes of CalFresh, they don't look at individuals to consider eligibility. So they don't look at the guardian and children and anything like that. They look at households. So who lives together and purchases and prepares food together. So the people who are in a household don't have to generally have any kind of legal relationship. They just have to do that, purchase and prepare food together. And so caregivers who are caring for children in their household can apply for CalFresh for them and just add them to their CalFresh application. Again, they don't need to be their legal guardian. They can just add them into their CalFresh benefits. Unlike CalWorks, though, there is no non-needy option for CalWorks or for CalFresh. So CalFresh is going to consider the income and assets of the entire household. So how much money they have in the bank and how much they're earning every month in terms of whether they are eligible for the benefit. They can't just get CalFresh for the child. Next slide. Here's just a table of the maximum monthly allotments from CalFresh right now. So you can get a sense of how much support CalFresh can provide for a family. Right now, because of COVID, this isn't necessarily how much a family would receive. So for example, if there was a household size of 2, the maximum grant would be $459, but depending on your income, that grant would be reduced to find out what your grant would be. However, during COVID, during the public emergency, the state has been topping everyone up basically to the maximum grant every month. So everyone gets their regular grant kind of at the beginning of the month, and then by the end of the month gets topped up to hit whatever the maximum grant is for their household size. So even for households that are on the lower end of things, it can be really beneficial to apply. Next slide. How to apply for CalFresh. There's a couple of websites to apply for CalFresh, including getcalfresh.org. And again, it's on the phone through the county as well. After you file an application, county staff will contact the client for an interview, and then they need to submit verification of their income. And that's generally how the process goes. Next slide. All right, we're going to talk just a little bit about foster care benefits. These are benefits that generally are applicable for families involved in the juvenile court, but can also be for non-relative guardians who get legal guardianship through the probate court, the process that Kristen described. So I just wanted to touch on it briefly. Next slide. So a couple of different people get foster care benefits. So resource families get foster care benefits. These are who we used to refer to as foster families. Relative caregivers who care for their relative children who are dependents of the juvenile court, who are in foster care, basically, colloquially. Those relatives have to go through the same process. It's called resource family approval. It's the same standardized process now for resource families or foster families who take in children they don't know, and relatives who care for their relative children who are in foster care. And then there's a third group of folks who can get foster care benefits, and these are non-relative legal guardians who've been appointed to be a legal guardian through the probate court. So that was the legal guardianship process that Kristen described. It is only for people who are non-relatives who are appointed by the probate court in that process. They are also eligible for foster care benefits. They can establish those benefits by calling their social services agency. Here in Alameda County, this is the phone number to the guardianship services unit. This is important to note because there's a little bit of a disparity here. So non-relatives can get these foster care benefits, which are, I think I have the number on the next slide, but it's $1,059 per month to care for a child, whereas relatives are the only aid they're eligible for without consideration of their income is CalWORKs, which is a much lower benefit, between about $300 and $400 per month. So it's a big difference there. Next slide. And so yes, here are the rates. So the basic rate is $1,059 per month. And then foster care has different rates for children who might have different needs. So dual agency rates are for children who are also regional center consumers. So for birth to 3 years, those who are receiving early intervention services, their rate goes up to $1,241. For those over 3, it's more than double to $2,771 per month. Level of care increases are for children who have maybe behavioral or medical needs. And then the chart at the bottom is for non-relative legal guardianship. As I mentioned, you'll see it's the bottom row. It's now all standard at that $1,059 for all age groups. Next slide. All right, this is just a little point to talk about the difference, to talk about CPS a little bit. So as Kristen mentioned, juvenile court is an option for relatives or other caregivers to be able to care for their relative children. And sometimes, when DCFS or CPS is involved with a family, they will ask relatives to care for children informally. And as we just saw with with foster care benefits, there can be a lot of financial support involved in being in the foster care system. And so sometimes DCFS will ask relatives to care for children without formally placing them into foster care, which deprives relatives of really significant financial support. And so if relatives are in that situation, they should ask DCFS for foster care funding. And if they're told no, they should ask for that notice in writing and contact their local legal aid right away. CPS isn't allowed to informally place children with relatives. They really have to kind of make a decision of if they believe there has been abuse or neglect, they need to file a petition in court and formally place the children with the relatives so that the relatives can access that really important financial support and all the other services that go along with this, or not. This is also a really personal decision though, and this is going to be a decision for families to make. It's not a light or easy decision for families to, decide that they want CPS involved with their family, and there are a lot of reasons that they wouldn't. And so it can be a really difficult decision to ask for this or to have relatives put in this position. So this is just some information to know that DCFS is not supposed to informally place children with relatives. And if they do, relatives can ask for foster care funding, which is significant. Next slide. All right, Medi-Cal, which is our free or low cost health insurance for children here in California. Next slide. So there are a bunch of different Medi-Cal programs, and it can be difficult to talk about the eligibility for all of them. But there is a much higher income limit for children to be eligible for Medi-Cal than adults. So generally the income limit is 266% of the federal poverty line, and children are eligible regardless of their immigration status. So if children need access to healthcare, their guardians should definitely apply, and there are lots of ways to do that, including through the Covered California website. Children who aren't living with their parents don't necessarily have their caregivers' income and resources counted towards their Medi-Cal application, and so they can often have a better chance of being eligible for Medi-Cal and all of the programs that can come along with that, which includes this EPSDT, the early periodic screening, diagnostic and treatment, which is all of that good stuff kids get, all the preventative services and treatment, which includes any mental health services that they may need. So it can be a great way for caregivers to help access mental health services for the kids they're caring for. Next slide. And how to apply for Medi-Cal. Like I said, the Covered California website is one way, or My Benefits CalWin, or on the phone to the county as well directly. Next slide. So other benefits, I'm just going to list them really quickly, so you can keep an eye out for them if you're working with relatives so they know. Next slide. So the child tax credit, this can be an important source of income, and whoever is caring for a child or providing most of the support for a child in that tax year should be claiming the child tax credit for them. WIC can be another source of a resource for healthy food, formula, those sorts of things. School meals. Children can be eligible for free meals at school, including PEBT, which was pandemic, EBT, which was extra food stamps that got mailed to families who had school-aged children during COVID-19, who weren't able to get their meals at school. And so they got extra money to buy groceries and food at home. Covered California, if children weren't eligible for Medi-Cal, could get subsidized health insurance, regional center services for children who might have developmental disabilities, subsidized childcare through either Head Start or CalWorks or state preschool programs, and subsidized housing, either Section 8 or public housing. This is important to know about because those programs can have specific rules about caregivers being able to add new people, especially children, to their leases, and what legal status they may need to have for those children. So some programs have demanded that caregivers be legal guardians in order to add children to the lease or to their voucher. That shouldn't be the case. So if relatives are running into that issue, please have them contact legal aid, and we can assist them with taking care of that issue and adding a child they're caring for to their voucher or to their lease on a subsidized housing program. Next slide. So here is how you can contact us. So the Youth Justice Project is the program I work for. Generally, we take referrals for issues concerning young people between the ages of roughly 12 to 26. We represent young people themselves. And so we're really only gonna work with older teens and young adults. But for any other legal issues or in any of the other programs we work in, domestic violence, housing, public benefits, you can call our legal advice line, which is highlighted in yellow. Open most days at 9:30, and sometimes it closes if we get a lot of calls, so best to call early. We also have a health consumer center that can answer questions specifically about Medi-Cal, Covered California, or private health insurance. That number is below. And if folks are in counties outside of the Bay Area, they can go to lawhelpca.org. Next slide. Oh, and that was it.
That's great. So much great information. Thank you so much, Marcy, Tori, and Kristen. We're just so appreciative, and Alicia. And we have time if people have questions that they want to ask. Okay, I see, Kristen, you have your hand up.
Yeah, I have a question for Tori. So we've learned over the years that sometimes children will be denied Medi-Cal because their caregiver is not a guardian. And we've learned to encourage caregivers to tell the agency that the child is medically indigent in order to get them on Medi-Cal without the guardianship. Are there magic words for the caregiver to use with a housing agency? Because that's a really common reason people come to us seeking guardianship, is because the manager at their building or the housing agency has said they need it in order to have the children in their current place or add them to the voucher to be eligible for a larger place.
Yeah, I don't know that there are magic words, but this is something that we have people come to us with as well. And different programs we found have different rules. And sometimes it's a matter of educating the programs about actually like what the rules that they are actually like receiving their subsidy under say. And so usually they're asking for too much proof if they're receiving a subsidy. And we can tell them that actually what the guardian or the caregiver is providing to them is sufficient. Usually if they can get a letter signed by the parent, proving that informal relationship or stating that they've given the caregiver custody or that they've made arrangements for that caregiver to care for their child, that usually works well. Without the parent's signature, though, it can be tricky, and we would need to probably advise on that particular situation.
Yeah, that's helpful. I didn't know that the parent signature would help. But yeah, it sounds like the different programs have different rules, so best to refer to the experts and have them call you. Thanks.
Great, thank you. And Celia, you have a question. Your hand is up. Please unmute yourself and ask.
Yeah. Okay. Hello. This was a great presentation, and thank you all so much. And since I'm a children's librarian, I'm always trying to build out our socio-emotional parenting collection. So I'm just wondering if any of the speakers have favorite books or favorite book lists that either talk about loss and grief for different ages, because it seems like, the age, what their development, what they might benefit from a book, and also maybe a child that's going through a foster care or a guardianship change. I'm always looking for the very best books to share with my family, because I think that's one way that we could open it up for kids to have their own experiences. So if anybody has that, when you send information later, I would really appreciate it. And I could put together some lists. Thank you.
Yes, absolutely. We might ask Alicia about that. And I know I have some lists of some books, and we'll be sure to find a list that will be helpful around grief and loss and adoption and foster care, because there are some good books that I know I have used in my practice. Okay, Preeti?
Thank you. Thank you, Kristen. It's always a pleasure hearing your presentation. So I'm from the kinship program at Family Support Services, and I have a question for Tori because I've learned something new today. Even though I've been working with kinship families for over 14 years. My question is, piggybacking Kristen's question about Section 8, my understanding was legal guardianship is a requirement for Section 8, adding them to the Section 8 voucher, because that's what we have been told by the Housing Authority, and so is Head Start. So we have been told by Head Start people that to get subsidized childcare, a guardian or a caregiver needs to have legal guardianship. So can we refer these families to you, or is there something different that we should know? Because that's what we are getting, that they won't be able to access these services without guardianship.
Yeah, I can say that, we have gone back and forth with the Section 8 providers about this issue, but there is specific guidance from the federal government, from HUD, about whether legal guardianship is needed, and it isn't. That there is a lower standard that caregivers can satisfy to be able to have their relative children stay with them and be added to their voucher. So that doesn't surprise me that is what they would say, but we can help advocate in those situations. So that is definitely a case that you could refer to us. As far as Head Start, that also surprises me, but I don't know the rule for Head Start specifically. Certainly, enrollment is possible in school with a caregiver authorization affidavit. And I would think that should be sufficient for Head Start, but given that there's also a subsidy involved or a benefit, I could see that would also be an issue. But Head Start is also a federal program and has some very specific rules. So I would have to research that particular question before I could give an answer. But you could absolutely refer those families to our office as well.
Thank you.
Great. Thank you. Are there any other questions? Looks like people have had their full. This was such a rich conversation today, so we appreciate you all so much. Alicia Montgomery, Marcy Neft, Kristen Boney, Marcy Neff, and Tori Perel. We just appreciate so much your willingness to be here with us and share your resources. And I'll ask once more if there's any other questions anyone has last minute. You can also email us. I'm the training administrator here, and we can help forward these questions to them if something comes up in the meanwhile. I don't see anything else in the chat, so I think without any further ado, we'll thank everyone for being here today so much, and appreciate you all filling out the evaluation. That helps us. It keeps our program going when we get evaluations from you all and what kind of trainings you're interested in. So what we'll say now is, if you wouldn't mind clicking that little red leave button in the bottom right-hand corner, because the trainers, myself and Leah, are going to have a little debrief. So we make sure we have all the materials to you and can email them out. We want to get the book list and all of that. And I want to thank everybody for attending, and have a good holiday season if we don't see you until the new year. And thank you all so much. I'm going to say goodbye for now.
Thank you.
And ask you, you're welcome. Thank you.
Thank you.
You're welcome. Thank you.